Hey everybody, thank you very much for joining us again for one of our awesome videos where we try and do two things. Number one, we try and teach sellers how sellers can help themselves. And number two, these videos allow me to introduce my awesome team to the entire world. So this is Rob Siegel. He is a lawyer. He graduated from Hofstra Law. He's been with us for 2+ years now. And we're going to be talking about what's called an office action with a trademark application. So Rob, do me a favor, introduce yourself, okay? So we get to know you and how awesome you are and the strength of your personality, and describe what an office action is when it comes to trademark applications.
Hey everyone, so CJ pretty much hit it right on the head with my bio, but basically a USPTO office action is a claim or an issue that's brought to our client's attention by the USPTO in regards to their trademark application. This week, one issue we dealt with was...
Hold on, before we get into the specifics, Amazon sellers, some sellers know how to apply for trademarks and some don't. So basically, when you come up with the mark, when you come up with one of your logos, you file for that trademark with the United States Patent and Trademark Office, USPTO.gov, and you can do the application yourself. They almost always go through, but not always. And if a seller has a problem with their application, if it gets kicked back for any reason, if someone else has a similar mark in the same category, you receive what's called an office action, and that is the government's negative response to your application, and that's what we're going to be talking about today. You apply for your mark, you have a problem, you receive an office action, and that's what we're talking about today. Okay, so this particular office action, what was the issue?
The USPTO here alleged that our client's mark was merely descriptive. So merely descriptive mark would mean that it only describes the goods or services that the mark is associated with. It'd be like...
I'm going to interrupt you so we get a good swing on this thing. Merely descriptive is like red notebook, okay? It's not a mark, it's not unique, it's not like the Apple with the bite taken out or the McDonald's M. It's just purely descriptive, and you can't get government approved trademarks for something that simply describes, what you have, like hot coffee. Okay, or dark roast. You can't get a mark for that. So get a little bit more of the detail, but we can't reveal the exact of it because all the information we have is confidential. So keep on going. What was the USPTO's issue with our client's application?
So basically, in order to get around a merely descriptive issue, you need to prove to the USPTO that the mark has acquired distinctiveness. So in this case, we were able to draft a document that proved to the USPTO that our client's extensive advertising, marketing, and general use of the mark in commerce for over 5 years was enough that the mark had acquired distinctiveness and was thus not merely descriptive.
What does acquired distinctiveness mean?
Essentially, acquired distinctiveness is just exactly how it sounds. It means that consumers have come to associate the trademark in their minds with the products or the services that you use under the trademark.
So acquired distinctiveness, if you can prove it, is like a workaround against the government's objection that your mark is only descriptive of your product. So if you've been using it for a while, if customers have come to associate your product with that mark you're filing, it's an end run. It's an argument against the government saying it's just descriptive. And that's what we are arguing in this office action. Now, what I'd also like to bring to you is how we succeed so that you can either use us or use our knowledge to help yourself. So Rob, was your argument successful?
It was definitely successful. Our client's mark was added to the principal registry this week.
So the application by the client first was unsuccessful. They came to us to help them with an office action, which is really what I recommend to sellers around the world. Give the application a shot, try and do it yourself. You don't need to pay us or any other law firm. And file your application. If you want us to do it, we can, but you don't need to. And then if you have a problem, if you get back in office action, then give us a call and we can help. Describe the time process. How long, if someone files for a mark, how long does it take to get a caseworker assigned at the government? How long does it take to either get that mark approved or to receive that office action?
Usually, once the application is filed, it's assigned to a USPTO examiner in about 30 days, give or take. After that, an office action can be issued right away or sometimes a few weeks down the line. But once responded to and dealt with, the total time for dealing with an application with or without an office action being issued can be anywhere between 9 and 12 months.
Okay, we also see the government changes, sometimes a little bit faster, sometimes a little bit slower. We've definitely had some marks approved around the 6 to 8 month mark, but just to be safe, just to give sellers an accurate time frame, if you say 6 to 12 months or 9 to 12 months, that's when you should have your mark approval. And if you have a private label brand and you have not applied for a mark yet, you need to do it yesterday, because if you want Registry 2.0, you have to have an approved mark. So these things are vital. So Rob, congratulations on winning the office action.
Thank you.
It's a huge win for our client, because what that means is our client doesn't have to rebrand and can get 2.0. If we failed in this office action fight, our client would have to choose between either abandoning that mark and rebranding his entire line of products, or walking away from 2.0. So both scenarios kind of suck, and it's really, really great that Rob was able to win this case and get this mark approved for our client. So really, really great job.
Thanks, CJ.